Morning, Mr. Anguera.
Good morning, Your Honor. My name is David Anguera on behalf of the appellant. With the court's permission, may I reserve 5 minutes for rebuttal?
You may.
This case presents a significant issue in terms of the constitutional rights of the civil litigant to an impartial jury and the consequences that trial lawyers face every day and trial judges in this entire country, not just this First Circuit. The issue of jury misconduct and jury improprieties has surfaced and continues to resurface under many circumstances. And the dilemma that we have as trial lawyers and trial judges is how do we deal with those circumstances depending on the time when the information is brought to light. And that's exactly what happened in this case. As this court knows, this was a significant piece of litigation involving a decedent who left 3 minor children and a spouse. It was tried before a jury, and the jury rendered a verdict against the plaintiffs. What we did not know, and what the court did not know, and was not revealed until several months later, was that based on the information we have now learned, this jury found out that there had been a settlement offer made of $3.5 million, and more importantly, that that settlement offer had been rejected by the plaintiff, Dr. Bouret. Well, let me backtrack, if I may, for a minute, and this is important. When that information was first disclosed, it was in May of 2013, which was 1 year after entry of the final judgment denying the motions for the new trial. So the district court's timing of this case and his opinion, which indicates the untimeliness of our motion, goes back to March, which is when the verdict was entered. And as we all know, final judgment does not occur when the original judgment is entered. It begins when the motions for the new trial were denied in May. This information about the jury misconduct was delivered under circumstances that can happen again and have probably happened in the past. And the reason for this is, Your Honor, as you well know, we are specifically prohibited in this circuit and in many other circuits and many other states, except for maybe 5 or 6 states in this entire country, from communicating with jurors after the verdict. And there's a rationale to that. We don't want some jurors harassed. Some courts have determined in certain states that we don't care. We think it's appropriate for jurors to communicate. And if there is misconduct brought to our attention, we will investigate and we will determine what the appropriate course of action should be.
Counsel, how much additional time passed after this information came to your attention before the motion for relief was filed?
The information came to my attention on May 22nd, 2013. In answering your question, the information was disclosed to plaintiff's trial counsel, Attorney Morales, the day before, on May 22. On May 22, my client called me and advised me that she had just learned from Attorney Morales about the jury misconduct that he had reported to her, and more importantly, reported to her that he understood he had an ethical obligation to bring this matter to the attention of the court. I asked the client, without disclosing attorney-client communications, please tell Mr. Morales to co-counsel with me. Allow me to get involved with my experience, and let's bring this matter to the attention of the court immediately because the court needs to deal with it. Within 24 hours, and I have his letter right here, within 24 hours after we communicated with Mr. Morales, he sent the letter withdrawing from the entire case. Not a motion to withdraw from the docket, from the court. A letter to the client withdrawing from the case, which then put the plaintiff in a predicament of having been abandoned by her trial counsel. I was not admitted pro hoc vice. I began an immediate search for attorneys in Puerto Rico to assist me with this case, and I could not find anyone for at least 2 months until I found David Efron. And this is in my affidavit. When I found Attorney Efron, he was the first one that said, there's a problem with jury misconduct in this area. We need to address it. We then immediately began to do proper research, prepare the proper affidavits, and filed a motion on September 4th of 2013, less than 4 months, contrary to the court's decision and the appellee's briefs. So within 3.5 months, we were able to take this information, despite the prohibition against juror contact, because we couldn't talk to the jurors and try to find out if we can assemble information, despite the fact that in this circuit, affidavits of jurors are specifically prohibited, so even if an affidavit had been provided, the court would excuse it. And more importantly, had we brought that motion earlier, Judge, it would have been denied because of the insufficiency of the evidence. And that's the dilemma that we confront in these cases.
If you're concerned about, you very much wanted an evidentiary hearing, correct?
That's all we asked for.
Okay, so
in stages.
Okay, so there is great concern about drawing jurors into this kind of post-judgment proceeding.
Absolutely.
They're not volunteers for this. There is a concern about getting them caught up in this.
There is.
How did you envision this evidentiary hearing playing out? Would it have been possible, as you envisioned it, to establish the facts that had been relayed about the alleged juror misconduct without actually calling jurors? Did you envision that possibility?
Yes, we did, Your Honor. And here's the precise procedure that we requested in our motion papers with the judge. We said, please let us subpoena, or you subpoena, Mr. Irizarry, who was the plaintiff's expert at the trial, who was the person that first heard about this information while he was in an investigation with the employer of one of the jurors. So the information came to him, and he, to some extent, as an expert in this case, felt he had an obligation to report it immediately to Attorney Morales. So I asked Judge Gelpi, I said, let's take it one stage at a time, Judge. I don't think we need to subpoena the jurors right now. Certainly, let's talk to Mr. Irizarry, and certainly, let's find out why Mr. Morales did not report this to the court directly, since he's still the lawyer in the case, and we need to talk to him to find out whether or not a juror needs to be interviewed, or perhaps his employer. Now, under Rule 606b2, if extrinsic and proper information is brought to the attention of the jury, which may objectively have prejudiced that verdict, and we submit that information that this juror knew, that these jurors knew, not only about the settlement offer, but the denial of the settlement offer, is clearly prejudicial. So arguably, a judge hearing testimony from Mr. Irizarry and from the employer of the juror could make the decision that objectively, based on all the circuit opinions, including the Sixth Circuit, particularly since 1954, in the case of Stiles, and then in the Usurth opinion later on, the Sixth Circuit has always said there is a presumption of prejudice when you bring this kind of information to the attention of the court.
The information that you brought, so that you think is enough, is, if I have it right, the employer, the expert told your client's former counsel,
yes,
that the employer of a juror,
yes,
had been told that this information had been exposed to the jury. That's the sum total of what you had.
That's precisely during the course of a subsequent aviation inspection.
Right.
They were present, and that's what he told them.
And so, I understand, let's say, if you had a juror saying it, how would that be possible? How is it ever possible? Maybe juror says it. But I'm saying, if you had a juror saying it to your client, or even if you had your client saying, I heard it from a juror.
Yes.
But what you have is a representation that an expert heard it from the employer of a juror.
That's right.
So what is the limiting principle on your idea of what's sufficient to trigger a Rule 60B investigation?
I will not say what mine is. I will say what this court has said about the type and sufficiency of evidence that you need. And this came from the Naran versus U.S. case, which I am sure this court is familiar with. And in that case, the court actually held a hearing. And they said that although the court held a hearing in that case, it's not a textbook model, because they didn't continue the interview. And it's, quote, preferable to allow juror interview out of an abundance of caution, but more particularly, the threshold requirement for a juror misconduct case under a 606b2 is, quote, a rather low threshold necessary to ignite need for the inquiry. So then Judge Scottawaya, in 2009, in the U.S. versus Bristol-Martin case, says, our case law has consistently emphasized that district court must ensure jury impartiality when exposed to intrinsic information.
Okay, that's fine, but go back to Neuron. What was the evidence that ignited it there?
In the Neuron case, what happened, it was a criminal case,
Yeah.
and then the criminal defendant's son, after the verdict was rendered, may I continue?
Go ahead.
Claimed that he had had a romantic relationship with one of the jurors.
Okay, so that's much more direct.
Well, but
that is much more direct than what you have.
Absolutely, I agree.
Okay, so why is this enough? And I don't understand how we'd have the limit. So suppose it was a friend of the expert.
Yes.
Said that he heard from the expert, that the expert heard from the employer, that the employer had talked to the jury. Would that be enough?
I think it's enough under a circumstance like that to allow the judge to
Okay,
inquire.
and that will go on potentially endlessly. A very good friend of the friend heard that the friend's employer. How are we supposed to figure out what the limit is?
Well,
when what you've got is not a direct person having had contact with a juror saying, here's what happened.
Right.
But instead somebody saying, I heard that somebody else heard that the juror had this happen.
If you allow me to answer, Your Honor, here's the predicament we had. Because Mr. Morales withdrew from the case, I did not know who the employer was, and he would not communicate with me. Mr. Echevarria would not communicate with us. So could we have gotten the employer's affidavit to say that? Absolutely. But we were prohibited from doing that.
But that might mean you lose under 60B. It doesn't necessarily mean that 60B has to accommodate the fact that you weren't able to acquire the information that would meet the threshold.
I think 60B needs to be a malleable cloud, a malleable standard specific to the circumstances of each case. I can sit here and debate hypotheticals with you until the cows come home, and some of them may sound ridiculous, but the fundamental constitutional needs in this case need to be addressed. And we don't have what one would consider multiple hearsay, nor do I argue...
No, you do have multiple hearsay.
But is hearsay really the standard?
No, I didn't say it. You just said you didn't have multiple hearsay. You have exactly multiple hearsay.
The point is that I think district court judges should be able to consider, because hearsay under the rules is to prove the truth of the matter. We are not trying to prove the truth of the matter of what the juror said. We're trying to find that if there's misconduct. So even though the court characterized this as hearsay, they were wrong. This is not hearsay. And that's why I submit to this court that when we as officers of the court become aware of circumstances like this, we have our hands tied. We can't touch the juror. We can't communicate. We ask the judge to conduct a brief hearing, and he denies our request based on what I consider to be an abuse of discretion. I did reserve some time, and my time is up. Should I continue, or?
No, not unless you want to use up your other time.
I'd rather reserve my time, if I may, Your Honor.
Mr. Martinez, good morning. Good morning, yes, good morning.
May it please the court and counsel. My name is Luis Martinez, and I'm here on behalf of the two defendants of L.E.'s Caribbean Aviation Maintenance and Charters Insurance Company of Puerto Rico. Respectfully, there's no doubt that Judge Helpe rendered a well-reasoned opinion based upon the record and the information that was provided to him. Clearly, what the plaintiffs in this case are doing is seeking to access to a very extensive and intrusive inquiry in an effort to attack a jury verdict that was rendered after a 28-day trial. The circumstances in this case basically show that the plaintiff did not come and meet the standards that are required. That is, some evidence, some threshold evidence in order to go forward. We believe that the assertion of Rule 47D as an impediment here is a red herring. And we say that because with regard to Rule 47D, the judge not only acknowledged that, Judge Helpe acknowledged it, but the rule itself doesn't prevent jurors from coming forward in addressing and telling the court about an impropriety. In fact, during the course of the trial, and this was part of the lower court situation, and the plaintiffs abandoned that on this appeal, juror number 4 came forward and said, look, I take your instructions so seriously that I want to point out to you that there's somebody out there sitting next to the plaintiff that I know. And there's no reason, in following that, and we included that in the brief, following that, the judge instructed the jury. He said, this is why we had a separate hearing with jury number 4. I want to advise you that if anything similar or untoward affecting the instructions that I gave you surfaces, you're to come to me. So therefore, there's no reason that if these jurors had access to something that they shouldn't have had, they more likely than not would have come to the court. Moreover, with regard to Rule 47 and the hearing that the counsel is seeking, Rule of Evidence 606B also limits what a juror may ask, and we may be asked, that is, and we already know what that situation is, even assuming that that were true. But that information, in our view, knowing about settlement discussions, is not, I would respectfully say, does not rise to the level of egregiousness and prejudice to the plaintiff. In fact, a case upon which plaintiffs heavily rely, the Orseth versus the city of Dayton, that case considered a similar circumstance. And that court found...
How does... Somewhat surprised that you're taking that fact. You seem to be taking a kind of almost a harmless error approach to this, in the sense that even if these reports are true about what jurors heard and how it played out in the jury room, it's really not that big a deal.
Well,
I'm frankly astonished by that argument.
I beg your pardon. That is our position is I'm referring to the Yorseth decision. In the holding of Yorseth, the court found that neither party was prejudiced by knowledge of that settlement. And that's part of the holding. And also, the court found 4 conceivable prejudices of knowing about settlement. And that court found all those 4 inure to the detriment of the defendant. In fact, one of them says that the jury could infer from knowledge of the settlement that the defendant feels or may have felt that they had responsibility. And that's what we're saying. I'm merely pointing out that the very case upon which the plaintiffs rely did not hold what I believe and I understand the plaintiff to be arguing. That judge himself recognized that the detriment, more likely than not, is to the defendant.
Well, the argument here, as I understand it, is that the jurors knew there was a settlement, they knew the amount, and in light of the rejection of that settlement, they chose to rule in favor of the defendant. The suggestion is that they had a good settlement offer. If they didn't take it, tough. We're not going to award them a verdict. I mean, that's the story that is spun out from this account.
With all due respect, that's not our position. The fact of the matter is, this is all speculation. It's multiple layers of hearsay, as Your Honors pointed out before. What I'm saying is that this particular case upon which they rely, even in those circumstances, even if it were to be true, common sense tells you that if the jury, it would be foolish for a defendant, for me as a trial lawyer, to attempt to let's tell the jury about the settlement.
Putting aside that issue, if the employer of the juror had come forward with an affidavit saying that they had been exposed to the settlement agreement, would that meet the 60B standard?
No, sir.
Why not?
No, because the 60B has to be taken in the totality of the circumstances. 60B is just not getting the substance, an assertion. I think 60B has to be looked in the timeliness, in the substance.
I'm sorry. Put aside timeliness. Just as far as the threshold, you said there was not enough of a threshold evidentiary showing made. Putting aside time, I just want to focus on that issue. If the employer of the juror had come forward with the information, would you say that was enough?
No, I would say no.
So if the juror came forward, would that be enough?
Only if the juror. If a
Only
juror,
if the juror, that's the only way it can ever happen?
Only if a juror.
Is that what the cases say? Cases require a juror to come forward for juror misconduct in order for 60B showing to be met?
The cases are very scant and few and far between about this particular issue with regards to settlement offers. But in every case where a hearing has been granted, what we find is that the hearing or the assertion is either being made by someone with immediate first knowledge, and it's done.
But that's like the employer of the juror.
Yeah, but during the course of the trial or shortly thereafter, because I don't think this is an extraordinary relief that's being requested here, and the rule has all of these requirements as this court has.
So you think the timeliness of when the information about the juror misconduct arises is relevant to the threshold question, independent of the timeliness of when they file the Rule 60B motion?
Yes, sir.
Okay.
Yes, sir. And
here, what, it was a 1-year gap from trial to when this information surfaced?
We believe it's 14 months.
14 months from...
And that's what Judge Helpe found. And then here's the other thing, if I may. They waited. If this is so extraordinary and so important to them, you don't need local counsel to pen a letter to Judge Helpe and say, hey, look, this is what happened. We were never notified. We were caught by surprise. And every day that goes by, I think any reasonable and rational person would find that that's detrimental to the defendant.
Why?
As time goes by, memories fade. Witnesses become unavailable. I mean, this was a massive, massive undertaking. I was the trial counsel below. And then for all of this to come out...
There's just a little bit of an oddity in your two arguments as you put them together, because you were suggesting that the threshold for making a 60B motion that would survive your standard would require them to have gotten more information than they received when they got the information. So if they were just doing what you said they should do, before they filed that 60B motion, presumably they should have done some investigation to try and get somebody with more first-hand knowledge.
What I'm saying...
But so they did that investigation. After a certain amount of time of doing it, they decide, you know what, we're not getting anywhere. Let's just file with what we've got. Then you say, well, now you're untimely. You should have filed the weaker filing earlier.
I'm not suggesting the filing, but at least the court should have been notified. And we cannot...
What would the significance of that be for the 60B?
Well, I think that at least the parties would have had notice of what is going on. The judge would have had notice. And with regard to the actions of the other trial counsel, I mean, I haven't seen anything that he's been removed or withdrawn other than the letter that counsel says, which are matters of the horse and record. I've never seen that. But the fact of the matter is that every day that goes by prejudices us. And what about the finality of judgment? This is a case. This is a case where the finality of judgment should take precedent and be given more weight, given the time that elapsed, the amount of information that was provided.
Counsel, this is obviously very important. You invoke finality of judgments. We've heard about the need to protect jurors from these kinds of post-judgment inquiries. We've also heard about the importance of the integrity of the work of the jurors. What if the district court had allowed the phased inquiry that the appellants here proposed? How would any of those interests, finality of judgments, the integrity of the jury's work, the interests of the jurors, how would any of those been compromised by allowing the limited inquiry that the appellants proposed?
Because once you open the door, once you crack that door, it's not just the limited inquiry of these individuals. You're going to ultimately expose the jury. And even if you were to talk to the jury...
Well, maybe if the door had been cracked open and an evidentiary hearing was held, there might have been cause to probe further. Yeah, sure, that's a possibility. But the other possibility is the judge could have concluded that there was no basis to go further. But here, the judge refused to consider that possibility at all by refusing to hold an evidentiary hearing, the limited evidentiary hearing that was proposed.
If the judge was following not only the fact that it was untimely and that the information was provided was insufficient, but the judge was also looking, in our view, at the rulings of the circuit, which says, look, you have to grant the 60B6 or 60B reliefs sparingly. And this did not meet that standard. And by the way, they also failed to tell the court and failed to meet the remaining standards, not the least of which is why, if we go forward and in fact they get what they want, which is a new trial, why there would be a different result. The allegations here do not affect the substantive evidence, and that's why the decisions rendered in this situation say you have to have an evidentiary foundation and you have to have egregious circumstances enough. And in our view, the further away you move from the entry of judgment, the more weight, finality of judgment has to be given. That policy. Otherwise, no verdict. We respectfully submit that this will open the door, if a hearing is even a limited one, you will expose every verdict in the future because we don't know. Someone could say, well, so-and-so heard so-and-so say that the juror knew this. If you could get enough to get someone to pen an affidavit and run to court and then cite this case, then what's to stop them from, and this court and the lower courts from engaging in this, in a sense, intrusive inquiry?
Thank you.
Thank you very much, Robert.
Mr. Aguilera, I think you have to sit down and wait for the other party.
Oh, I'm very sorry.
Good morning, Your Honors. May it please the Court. My name is Tim Getz, and I represent Appellee Robinson Helicopter Company. Just to expand just a bit on what Mr. Martinez was saying, I would just like to read from the court order something that the court particularly took note of, and I think it's important. And this, again, is the court that has firsthand knowledge of what went on in trial, the court that it's an abusive discretion standard. This court was actively engaged in the trial, and the court stated...
That really is irrelevant, isn't it? Because all of this, if it happened, it was behind the scenes and nobody knew what was happening.
Well, I think it is somewhat relevant, Your Honor, given the fact that it is an abusive discretion standard. And I think
that part is not what I'm referring my comments to.
Okay. I guess my only point there is that this judge was in a unique position to know whether appellant's justification for seeking extraordinary relief was worth investigating jury deliberations. And the court, in fact, indicated, and I quote, the court would be potentially required in any civil case to grant an evidentiary hearing following a jury verdict based on mere rumors, regardless of how much time had elapsed since judgment. And Rule 60B is not satisfied that easily. And I'd just like to make three quick points. Number one, appellant's motion was untimely under both Rule 60B-3, which has a strict one-year limitation period for purported misconduct. The court actually generously applied Rule 60B-6, which is the catch-all provision, although the court also indicated that you cannot use that catch-all provision to escape the time constraints of Rule 60.6.1, which is the one-year limitation.
But B3, you said was misconduct. It's not juror misconduct.
Well, I think they've alleged more than juror
No, but I'm saying
misconduct
for
in a sense,
B3 covers misconduct by an opposing party.
which I think has been alleged. I guess they're saying it doesn't matter how the jury got that information.
That would make B6 more operative, right?
B6 is what the judge actually analyzed it under. We believe that he could have analyzed it under B3. However, I would agree. The judge did, I think, analyze it more generously under B6. And even under B6, I think it raises a bit more of a higher standard under B6, given that it is kind of a catch-all provision that says any other reason. So,
And it's untimely under B6 because
the evidence was insufficient.
No, it's untimely under B6 because you said it was untimely under B6.
Untimely under B6.
I understand why it's untimely under B3 because it's
right.
But why is it untimely under B6?
Under B6, there's a reasonableness standard.
Yeah, and why was it unreasonably late in the filing?
It was unreasonably late in the filing, because it was months after they found out about this information that they didn't notify any of the defendants. They didn't notify the court. They didn't notify anyone. So I believe as the more time goes by.
I understand more, right? But both you and the prior counsel are suggesting that somehow filing notice to the court is relevant to the timeliness of the Rule 60 filing. Is there any precedent for that?
Certainly, at least, if they give us notice, I believe the more time that goes on, again, I agree with Mr. Martinez, every day that goes by, we are prejudiced. And again, real quickly, my points were the untimeliness, but I think I should get to maybe my third point to address, Your Honor, in that there's a requirement. They have the burden to show that the defendants wouldn't be prejudiced by this. And the more time goes by, every day, we are more and more prejudiced in this case. Mr. Martinez's client...
Why is that? You're just relying on memory dimming? Is that the rationale for every day?
Memory dimming, Mr. Martinez's client, Caribbean Aviation Maintenance, actually went bankrupt. Witnesses scattered. They no longer had an employer. The more time that went by, people were going different places. Even during the trial already, we had people that we had to hunt down that were over in the mainland U.S., and it was difficult. And the more the time goes by, I believe we had something close to 40 witnesses.
I understand this is the basic point, but I guess I'm trying to figure out what standard for timeliness are you contemplating? Is it immediate? They have to do it within a week?
May I continue?
Go ahead.
I mean, it's a reasonableness standard, and I would argue certainly that they should do it as soon as they know about it. I mean, a week, certainly, I would argue within days. I mean, they contacted their own counsel within days, supposedly, which I think would have been appropriate. But we should have known within days, certainly within a week, not months later. So I guess that's the point that I was trying to make, that for every day that goes by, we are more and more prejudiced, so the timeliness is important, and I guess that was primarily where I was going with that.
Thank you.
Thank you, Your Honors.
Thank you, Rod. Mr. Aguirre.
I will limit my comments to the issues raised by my brother counsel in the order in which they were raised. The allegation is that the court's order indicated that there was an unreasonable time. This is specifically what Judge Gelpi wrote. Seeking relief 18 months after final judgment pushes against reasonableness. First of all, the number of 18 months is completely wrong. Second, this case has repeatedly stated, including in the case of Cotto versus U.S., Judge Selya, in determining a motion under Rule 60b-6, says that the issue of reasonableness depends on the circumstances of every single case, and that there is, in fact, no ironclad rule. In fact, the famous quote from the poet Emerson that was used in that opinion, quote, "Reasonable time is a mutable cloud, which is always and never the same." And in this case, what Judge Gelpi has done, for whatever reason, is he went back 18 months to the date of the original jury verdict and used that as a guiding point to begin the clock. My position is that's not when the clock should begin to run on a 12b6 motion. The time clock runs here when the information came to light. And we did everything reasonable under the circumstances that we can do to bring this matter to the attention of the court. Brother counsel suggests that I write a letter to the judge. I think the three of you might agree that had I done that, they'd move against me and claim...
Would you agree that possible prejudice to a defendant in a case like this is relevant to the determination under 60b6?
I agree that the principles of prejudice to both parties is relevant to the determination.
So it can't just be when you get the information that's a relevant time frame. I mean, by that logic, it could, if it only comes to you 2 or 3 years out, any concerns for the prejudice of the defendant still doesn't matter, and that can't be right.
And I understand that, Your Honor. However, if you read the appellee's briefs in this case, the allegations of prejudice are based on pure speculation and hearsay. There were no affidavits presented by them as part of any motion.
There's certain irony in you making that argument.
No, I mean affidavits by their...
I'm saying there's a certain irony in you making an argument about pure speculation based on
That's right.
affidavits when your 60B motion depends on that.
No, but I'm talking about affidavits by the lawyers about witnesses that they no longer control,
but
they had control over their ability to communicate.
I see.
Just that's the difference. That's a real difference. I didn't have that opportunity. So yes, the courts have said there's a balancing of the prejudice. But when you take the constitutional rights of a civil litigant to an impartial jury versus a brief inquiry to find out if jury misconduct actually occurred, I think that must yield. The finality of judgment principles must yield to the constitutional rights of our litigants. And I think that this court needs to address that issue, present it in a way that we as trial lawyers will seek some guidance and know what to do with these circumstances, not just write letters to the court unless you think that's appropriate. We'll be happy to do that. But my understanding of the ethical obligations went far beyond that. I needed to present some reasonable evidence that misconduct occurred. To address one of the issues raised by, I believe it was Judge Barron, it's been our experience, and I'm sure yours, that this information can come from all sources. Let's suppose that one of the court officers was the one that got this information. Let's assume it's a court clerk, a stenographer, a judicial law clerk. Are we going to discredit that simply because it came from another source?
No, but my question to you, and I still don't quite have an answer to it, suppose it was from the friend of the employer of the law clerk. Is that enough?
Enough for the initial inquiry. If the source is coming from an attorney, and this has been reported to the attorney, number one, we have an ethical obligation to bring it to the court's attention. The question then becomes is what's the court's obligation to fashion the proper inquiry under those circumstances? And I submit to this court that submitting a letter without conducting some kind of an investigation is certainly not enough. And there is no well-reasonedness to this opinion. In fact, even on the second basis of his opinion, where Judge Gelpi wrote, the plaintiffs present to the court only hearsay evidence of the supposed tainted jury deliberations. These materials are insufficient to push plaintiffs' claims beyond the daunting threshold required by Rule 60B. And he cites the Naran. The Naran case doesn't say there's a daunting threshold. The Naran case says exactly the opposite. It says there's a very low threshold. So I respectfully disagree with Judge Gelpi's opinion. He got the timing wrong and he got the law wrong. And I ask that this court remand it back to Judge Gelpi, conduct the appropriate hearing, and justice may be served. Thank you, Your Honor.